Like I said, my name is Alexis and I'm the outreach coordinator for Renters Helpline.
And my name is Virginia Mazariegos, and I am the Tenant Protection Advisor at the Renters Helpline.
Renters Helpline is funded by the City of Sacramento, Sacramento County, Citrus Heights, City of Folsom, Rancho Cordova, and the City of Elk Grove. We partner with Project Sentinel, which we send over all of our fair housing cases to, and then Legal Services of Northern California, and we send over all of our discrimination cases to. We also partner with SAC Self-Help Housing. We are a branch directly underneath them. So what we do at Renters Helpline, we help educate tenants and landlords on their rights and responsibilities. We offer tenant and landlord dispute resolution. So if you have a tenant or you are a tenant that is having an issue with their landlord and you don't feel comfortable or you don't know how to go about it, we can go ahead and contact your landlord for you and help try and resolve the issue. We identify housing discrimination cases, which we then send over to Project Sentinel. We provide referrals and resources for legal assistance, such as Legal Services of Northern California. And we offer all of these services in over 200 languages. Some common concerns we see are rent increases. So ensuring that the landlords are properly and legally raising the rent at the correct rate. And then having repairs made. So making sure landlords are making repairs for your tenants or the tenants in a timely manner. We see a lot of termination of tenancies and evictions, security deposit refunds. So ensuring that you are receiving your security deposit within 21 days, reasonable accommodations, and then tenant protections due to COVID-19. And then I will go ahead and turn this over to Virginia, and she's going to go over the Tenant Protection Program with the City of Sacramento.
Protection Program. The Tenant Protection Program, or TPP, was passed by Sacramento City Council and took effect on September 12, 2019. The program was created to assist residential tenants with increasing rental rates by establishing limits on annual rent increases. For longer-term tenants, it also provides protection from unwarranted termination. So for rental increases, that protection starts as soon as the tenant moves in. The program helps provide renters in the City of Sacramento with more stability to help them remain in their rental units, assist tenants and landlords with questions and concerns, facilitate fair rate of return and pre-eviction hearings, and enforce the city codes. This ordinance imposes rent caps and just cause eviction requirements on some, but not all rental properties within the City of Sacramento. So in short, this ordinance, again, has two parts to it. One is the rental cap and the other is eviction protection. All right. Rental property subject to TPP. The units that are included in the protection are multi-family units built before February 1st of 1995, mobile home rentals, single occupancy rooms and hotels rented for longer than 30 days. Exempt properties would be units built after February 1st, 1995, single family homes, condominiums, units occupied by landlord, property agent, or immediate family member, government subsidized low income housing. And I again can't stress enough that this is very, very particular to the City of Sacramento. Rental rate increase. Annual rate increases cannot exceed 5% plus the change in consumer price index, or commonly known simply as CPI. Maximum increase cannot exceed 10%. Maximum rate updated annually and takes effect July 1st. Rent increase cannot occur more than once every 12 months. Rent includes all charges for use and occupancy of the rental unit, including any separate charges for housing services such as utilities, parking, and pets. So this is very, very different to the statewide ordinance that would cover folks in the county. That's why it's a very, very important to remember that TPP is very particular to the residents within the city of Sacramento, because this includes, the rent cap includes utility bills, such as your sewer or your water. So this is very, very, very important to note. So the ordinance says that it's 5% plus CPI, and the CPI changes every year in July 1st. Right now, our current CPI is 7.7. So this is more than the rent cap, right? So for right now, it's the maximum your landlord can raise your rent is 10%. Rent increases between tenancy. New base rental level is allowed when a unit is voluntarily vacated or rental agreement is terminated as allowed by ordinance. Landlord may establish base rent for new tenant under a new rental agreement after the rental unit is vacated. Any rent increases for new tenant must apply with TPP maximum rate limits. So basically, if a tenant moves out of a unit, the landlord can bring up that unit to market rate. So if that tenant was paying $1,500 and moves out, now the landlord can go ahead and put that unit up, say $2,000. So the next tenant that comes in now is going to pay that rate. Okay. Rent increases month to month or fixed term lease. So for fixed term lease, at the time of renewal is when the landlord can raise the rent. A fixed term lease means that you can't change anything on the lease, including a rent increase. A month to month at any time with the proper notice. Of notice required, 30-day notice is required for an increase of 10% or less. A 90-day notice is required if the increase is going to be greater than 10%. Service methods. So there is only two ways that your landlord may serve you with the rent increase notice. One is personal delivery, and the other is by first-class mail. It's mailed, a landlord must allow additional time. So 5 days should be added if they're mailing in from within California, and 10 days added to the notice mailed from states other than California. Eviction protections. Landlord must offer to extend or renew rental housing agreement if the tenant has resided in the unit for more than 12 months. Evictions are prohibited without just cause once the tenant has resided in the unit for more than 12 months. So that's when that protection kicks in, right? So 12 months plus 1 day is when that eviction protection kicks in. Again, when as soon as the tenant moves in, that rent cap protection kicks in right away. But for just cause evictions, the tenant must be in that unit for 12 months plus 1 day. Landlord must agree to extend or renew the lease before it expires for just cause eviction protections to become effective. If the landlord notifies the tenant that the lease will not be extended before the lease expiration date, the tenant is not entitled to eviction protections. That status does not change if the tenant remains in the possession past the lease expiration date as a holdover tenant until they vacate the unit. So if a tenant moves in and they have a 1-year lease agreement and that landlord gives the tenant a 30-day notice that they're not going to renew their lease, and that tenant thinks, well, no, I'm going to stay that 12 months plus 1 day because then I will be protected. That doesn't work that way. So once the notice is given, that's it. If the tenant chooses to remain in the unit and go through the eviction process, then they may do that, but they will not have that protection. Cause reasons. So this would be tenant fault. So if the tenant fails to pay rent, breach of rental agreement. So anything from a pet policy to smoking policy. So anything in breach of your rental agreement, a tenant can't be evicted. Criminal or nuisance activity, failure to give access. Failure to give access means that if your landlord gave you a 24-hour notice to enter the unit for maintenance and the tenant continued to deny access, this is when a tenant can get evicted. Just cause reason, no fault of tenant. So the tenant has done nothing wrong in this case, and the landlord wants to ask the tenant to vacate. So these are the just cause reasons that are. So the first one is necessary and substantial repairs requiring temporary vacancy of the unit. Now, these repairs are going to make the home uninhabitable for 30 days or more. It'd be 30 days or more. The landlord is still required to give a 120-day notice. However, once the repairs are done, the landlord must offer the unit back at the same rate the tenant was paying. Okay. The second reason is owner move-in or immediate family member. So the owner or the immediate family member has to make a 1-year commitment. It's actually 12 months plus 1 day commitment to live in the unit. So they can't simply move in and 3 months later decide that it's not working out. Okay. The third reason is withdrawal from the rental unit off the market. So removing the rental unit off the market, and the landlord has to remove the unit off the market for, again, 12 months plus 1 day. Also, if they're planning to demolish the unit, that's also a reason to terminate the tenancy. Again, for no fault, these are the reasons. Landlord is required to provide at least 120-day advance written notice to the tenant. Notices must be written notice. Landlord must try and serve you in person with a written notice. The landlord has the right to post it on your door and mail it to your address. Notices cannot be stated to the tenant verbally, through text, or by email. So it's very important that the tenants know that, again, if you're going to get a rent increase, it needs to be served properly, hand delivered or mailed. Eviction notices, again, must be served properly. These, however, can be hand delivered, posted, and or mailed. And mailing, you always have to allow an extra 5 days for the process of mailing. All right. So tenant pre-eviction hearing petition. The ordinance provides tenants who have resided in the rental unit for more than 12 months with the right to a hearing to challenge the landlord's basis for eviction. So if you get a 120-day notice or maybe you get a 60-day notice and you want to challenge it, tenants have the right to petition for a hearing. Any member of the tenant household may submit a tenant petition for pre-eviction hearing form to TPP to contest the landlord's termination of rental housing agreement and eviction notice. Due to the need to address the merits of the eviction by a hearing examiner before the date of Superior Court unlawful detainer hearing, the time frame for the tenant to submit a pre-eviction hearing is short. The tenant requests assistance or file a complaint. So there's 2 ways. They can contact the Tenant Protection Program directly. They have a wonderful website with the forms, or they can call us, Renters Helpline. They're going to need some information. They will need a name, contact information, such as your email or phone, your rental unit address, rental housing agreement, and or date of tenancy. So the reason they ask for that, usually it's the first page of the rental agreement, and that verifies that you've been, or the tenant has been in the unit for X amount of time. Okay. Reason for request. So what is it? Is it a rent increase or is it an eviction? Any documents received. So whether you got a rent increase notice or termination of tenancy notice, they would like to take a look at that notice as well.